The Subcommittee on Fisheries, Water, and Wildlife will now come to order. Thank you for all of you for your attendance here this morning on an important bipartisan bill offered by my colleague, Senator Barrasso. I'm proud to be an original co-sponsor of S. 1140, the Federal Water Quality Protection Act, as this bill would address many of the concerns we've all been hearing regarding the EPA and Army Corps' proposed Waters of the United States rule, or WOTUS rule. Over the last few months, we've held several hearings, including 2 field hearings in Alaska, on the proposed rule where we heard testimony from a variety of witnesses, including the EPA Administrator, Assistant Secretary of the Army, state and local government representatives, as well as other stakeholders. This bill is a continuation of these efforts and would require agencies to withdraw the current proposed WOTUS rule and issue a revised rule proposal that adheres to a series of principles delineated by Congress only after completing numerous procedural requirements bypassed the first time that this rule was promulgated. In our first hearing on this issue, I asked the EPA Administrator McCarthy to share with me the agency's internal analysis justifying this rule. I'm still waiting for a response. It was a simple request, and I believe it's outrageous that the EPA cannot issue a legal opinion citing the legal justification for this rule. It would be useful for the EPA Administrator to not only address that legal justification of that rule, but the front page article in the New York Times today on accusations that the EPA is violating the anti-federal lobbying law in relation to this rule. It would be good to have both of those legal analysis from the EPA as soon as possible. 3/5 of the states oppose the proposed WOTUS rule, along with more than 300 trade groups and associations from across the country. While it is Congress's job to prevent this massive expansion of federal jurisdiction, we must do it in a way that protects our waters and allows states the opportunities to fulfill their roles as co-regulators under the Clean Water Act. A huge percentage of Alaska already falls under Clean Water Act jurisdiction. This means that those building or doing business on or near these waters have to wrangle with the federal government to obtain costly permits and approvals. While there is no doubt that many of these waters, such as the Yukon and Kuskokwim rivers and their tributaries, are clearly jurisdictional under the Clean Water Act, the proposed rule seeks to go further and would encompass many waters that Congress never intended to be jurisdictional. This massive expansion of federal authority will have harsh consequences for not only those who are trying to develop the land, but state and local governments charged with protecting their own unique resources. It is also an expansion of Clean Water Act jurisdiction that I believe only Congress can grant. Alaska has some of the cleanest waterways in the world, resulting in vibrant, world-class fisheries and award-winning drinking water. We need to ensure that any effort to clarify federal jurisdiction under the Clean Water Act does not jeopardize these characteristics that are so fundamental to the identity of Alaska and other states throughout the country. Today we are here to discuss this very bipartisan bill that would not only help to clarify jurisdiction and prevent unlawful federal overreach, but it would also help ensure that the protection of Alaska's precious resources remain in the hands of those who live near and rely on them. Thank you all for being witnesses this morning. I look forward to hearing from you. I yield the remainder of my time to my colleague, Senator Barrasso.
Well, thank you very much.